Hello friends, today we discuss where do we file an application or petition for appointment of an arbitrator. As we all know, Arbitration Act provides for an alternate mechanism rather than going to courts directly. But what happens if both parties or more than one party cannot agree to a single or more than one arbitrator as stipulated by their contract? The mechanism is provided under Section 11 of the Arbitration and Conciliation Act. It provides for the aggrieved party who has been asking for an appointment of an arbitrator to go to a particular court after giving 30 days notice. So 30 days notice is mandatory. You have to give the notice to the other side. If within that 30 days they do not agree to appointment of an arbitrator as suggested by you, or if the contract stipulates they are supposed to appoint, like most of the government contracts, the government person will appoint an arbitrator as per the panel or otherwise, and they don't, then you have the remedy under Section 11 of the Arbitration and Conciliation Act to go to the High Court under whose jurisdiction the subject matter has arisen, or to the Supreme Court in case of an international arbitration. Now, the interesting thing is there are certain times we find in practice that various persons are wrongly advised or ill-advised, unintentionally obviously, and they file these kind of applications under Section 11 for appointment of an arbitrator before civil courts, before a district court, or sometimes now after the mushrooming of the commercial courts, in front of commercial courts. But the law is very categorical. It only the High Court in case of a domestic arbitration and only the Supreme Court in case of international arbitration can appoint the required arbitrator or the umpire or a panel. It cannot be done otherwise. So no civil court, no commercial court or the district judge can appoint, or any other body for that matter, can appoint an arbitrator in case of a domestic arbitration, and even no high court can appoint an arbitrator in case of an international arbitration. It just cannot be done. It is categorical law and is firmly entrenched, and there are umpteen judgments on this point. One of the interesting judgments which, if people are so inclined, can see and read is 2015 1 Supreme Court cases, page 32, Associated Cements, which will be a good judgment to start off and explains the procedure. So be advised accordingly, and always ask your lawyer when you are going into arbitration, and I'm sure your lawyers will give you the requisite advice over which High Court you have to apply, or which, if there is case be, to the Supreme Court. Please don't file in any other court, because this only can be rejected and there can be no remedy. Thank you, and have a nice week ahead, and please let me know what you think of the video. Thank you.